Well, good evening, everyone, and welcome to this evening's seminar on prosecuting the crime of aggression, establishing the Special Tribunal for Ukraine at a critical juncture for international justice. This evening's webinar is going to be recorded. I'm Professor Catherine Renshaw. I'm the Dean of the School of Law at Western Sydney University. I'm also Deputy Chair of the International Law Section of the Law Council of Australia. And one of the primary purposes of the Law Council of Australia is defending the rule of law, including the rule of international law. The subject of this evening's webinar concerns one of the most consequential questions facing international law today. How do we ensure accountability for the crime of aggression in the context of the war in Ukraine? The prohibition on the use of force is the foundation of the modern international legal order. At Nuremberg, they called the crime of aggression the supreme international crime. But despite all that, the mechanisms for prosecuting aggression remain limited, fragmented, and in many respects inadequate to current realities. This evening, we have an extraordinary panel of people to discuss the complex political and legal questions at the heart of prosecuting the crime of aggression in the context of Ukraine. We have first His Excellency, Mr. Vasyl Murashenko, the Ambassador of Ukraine to Australia. We have Ambassador Anton Koryanovich, the Directorate General for International Law and Legal Counteraction to Aggression in the Ministry of Foreign Affairs of Ukraine. We have Mr. Mykola Yorlov, a councillor in the Ministry of Foreign Affairs of Ukraine. We have Dr. Irina Mudra joining us soon, the Deputy Head of the Office of the President of Ukraine. Associate Professor Carrie McDougall from the University of Melbourne. And we're extremely honoured that we have the Executive Director of the International Bar Association himself, Dr. Mark Ellis, with us tonight. So the way things will go is that I will ask some general questions to each of the panel members, and then we'll open up discussion to questions from the audience. But at the beginning, I would like to offer His Excellency Ambassador Vasyl Murashenko to make some opening remarks.
Professor Renshaw, thank you very much for your kind introduction of the panel and for moderating this very important discussion we are having today late in the afternoon in Australia and early morning in Europe. Indeed, justice is extremely important, and for every Ukrainian, we all are aspiring to see peace as soon as possible, but to achieve that long-lasting peace, we still need to work hard. But in addition to the end of hostilities, Ukrainians want to see justice. And I think this is an extremely important stream that Ukraine as a country is pursuing, and we rely on the support we're getting from our international partners. We are very grateful to Australian government for becoming an associate member of the Register of Damages, which is one of the key elements in the accountability track that Ukraine is currently pursuing. More so, we recently were very pleased to have a visit of Mark Ellis, Dr. Mark Ellis, as well as Mykola Yorlov to Australia and New Zealand, and they were able to meet and engage here with an Australian government, as well as with the government of New Zealand, as well as a number of other Pacific countries, which was extremely important to raise awareness about what we're trying to achieve in Ukraine. Since my arrival to Australia 4 years ago, I have learned the concept of a fair go. For every Australian, that concept is extremely dear. It's something which is part of that Australian spirit, if I can say so. That's about the justice and fairness. And I think that's an extremely important element. And maybe that's the reason why Australians have reacted so strongly when Russia invaded Ukraine 4 years ago, and they have felt like never before that Ukraine is an underdog which needs to be supported. And ever since that support has been coming. Of course, Australia has already the history of prosecuting Russia for the crime related to MH17 when it was shot down by the Russians over the airspace in Ukraine in 2014. So that we already have an experience of working together with the Australian government and the Dutch government on making sure that Russia is held accountable. However, of course, the Special Tribunal on the crime of aggression goes beyond that. We also hope that we can tap into the talent of the Australian international lawyers. There is a very strong school of international lawyers in Australia, and it goes back to the times when Australia was one of the founding members of the United Nations. And probably the legacy of your foreign minister, Herbert Abbott, who played a very crucial role in San Francisco at the establishment of the United Nations, and then later on, his work as a president of the UN General Assembly when the Human Rights Convention was adopted. And I think in Australia, that school and his legacy still lives on. Hence, for Ukraine, it's so important to be able to engage and involve the expertise of your international lawyers as well as the expertise of the government in making sure that we can keep Russia accountable for the crime of aggression. Of course, for me, it's the easiest part is to do this opening remarks, and I'll probably stop here, but also like to express my thanks to the Law Council of Australia for kindly hosting this event. And I'm very pleased that we have the cream of the crop from Ukraine of a team which is our international lawyers, including Dr. Irina Mudra, the Deputy Chief of Staff to the President of Ukraine, as well as Anton Koronevich from the ministry, who is a focal point for this important track. And I'm very pleased to be here with you.
Thank you very much, Ambassador. Dr. Mudra, we may turn to you first to lay the landscape for us. If you can explain the political necessity for a special tribunal and discuss how the establishment of such a tribunal could impact the peace process.
I do thank you very much, distinguished colleagues, ladies and gentlemen. For me, it's true honor to address the legal community of Australia today. There are moments in history when international law is tested not in courtrooms, but in reality itself. Moments when legal principles stop being abstract concept and becomes questions of global security and survival. This is such a moment. What Russia has done against Ukraine is not only a war against one sovereign state. It is a direct challenge to the international legal order created after the Second World War. The central question before all of us is very simple. Will international law remain meaningful when confronted by open aggression? Or will the world gradually accept that powerful states may violate borders, wage wars of conquest, deport children, and still avoid consequences and accountability? This is precisely why the Special Tribunal for the crime of aggression against Ukraine matters so profoundly. Because aggression is the leadership crime, the origin crime from which all other atrocities flow. Without the political decision to launch this war, there would have been no destroyed cities, no mass graves, no deported children, and no millions of displaced people. And this conversation is not only about Ukraine. It is about whether the international community is prepared to defend the principles that no state and no leader is above the law. And for countries like Australia, as just our ambassador said, nations deeply committed to the rule-based international order, this question carries very global significance. So what is, answering your question, what is the political necessity for the special tribunal and how does its establishment impact the peace negotiation? The political necessity for this special tribunal is rooted in one fundamental reality. Without accountability for aggression, the international legal order becomes vulnerable to collapse. The crime of aggression is fundamentally different from war crimes. War crimes concern how a war is fought. Aggression concerns the decision to launch the war itself, the political and military leadership decision that made every subsequent atrocity possible. Today, there remains a serious accountability gap because of jurisdictional limitations within the Rome Statute. The International Criminal Court cannot fully exercise jurisdiction over the crime of aggression committed against Ukraine. At the same time, the United Nations Security Council is blocked by Russia's veto power, and this creates a structural weakness in the global system of justice and security. And this special tribunal is exactly designed to close this gap. Politically, this matters because allowing aggression to go unpunished would create an extremely dangerous precedent. Every authoritarian leader is watching whether borders can be changed by force and whether military power can override international law without consequences. That tribunal, therefore, serves not only justice, but deterrence. Impunity is contagious. Once aggression becomes tolerated in one region, it inevitably weakens security everywhere else, including in strategically sensitive regions such as Indo-Pacific. Importantly, Ukraine believes justice is not an obstacle to peace. Justice is what makes peace durable. History teaches us clearly that impunity never produces lasting peace. Accountability does, law does, responsibility does. This is also why the tribunal is politically unique. Unlike Nuremberg or Tokyo, we are building this institution while the war is still ongoing. This is not victor's justice. It is collective legal action by the international community in real time, demonstrating that aggression cannot become normalized in 21st century. And today we are no longer discussing a theoretical concepts. The tribunal is becoming a reality. This week in Chisinau, states are formally launching the next institutional stage through the enlarged partial agreement under the Council of Europe framework. 25 states have already confirmed their participation. The tribunal's advanced team is already operating in The Hague and Strasbourg. Judges will be appointed, prosecutor will be selected, cases will be prepared. The International Center for Prosecution of Aggression is working already for more than 2 years. They are collecting evidences of aggression. They are preparing cases to be further transmitted to the tribunal. Importantly, that Australia has already played a constructive and respected role throughout this process, and we value deeply. We deeply value Australia's engagement in the core group negotiations and the contribution of Ambassador Greg French and his team. But today, Ukraine asks our partner Australia for something more. We ask for Australians' leadership because Australia is not simply an observer in global legal affairs. Australia is one of the world's most respected voices on international law and the rules-based order. Australian lawyers, judges, diplomats, scholars helped shape modern international criminal justice. Australia has consistently defended multilateral institutions and legal accountability. And when Australia speaks in international forums, including across the Indo-Pacific and the Pacific region, people listen. We therefore ask for leadership in three specific areas. First, we ask Australia to join the enlarged partial agreement on the Management Committee of the Special Tribunal. This would send a strong signal that accountability for aggression is universal, not regional, not selective, not limited to Europe. Second, we ask Australia to help engage Pacific Island nations in this accountability coalition. Many Pacific states have already clearly condemned Russia's aggression. Australia has the relationship, credibility, the regional influence to help transform political support into institutional participation. And there are different forms of this participation, and I'm sure my colleagues will speak on that. And third, we ask for a continued Australian support across the broader accountability architecture, including the future International Claims Commission, which is also in the process of establishment, support for the ICC, for the universal jurisdiction investigations, and sustained sanctions pressure. Ukraine will never compromise on justice, and we ask Australia to stand with us. Thank you.
Thank you very much, Dr. Mudra. Can I ask you, Dr. Anton Korinevich, to explain more about the Special Tribunal itself, the contribution that other states have made to its establishment and the structure and nature of the tribunal, exactly where we're at now?
Thank you so much, Professor Renshaw. Good morning from Kiev. Good evening to Australia. It's a big pleasure and honor to be present today on this important discussion, and many thanks to the organizers who made it possible. Dr. Mudra has already mentioned the important input of the Australia's team to the core group discussion, in particular Ambassador Greg French and his brilliant team, and this is really what we appreciate a lot. And it is very important that Ambassador French, together with his team, continues to be engaged in the Special Tribunal process, in particular in the GT Tribunal Working Party in the Council of Europe in Strasbourg. So this cooperation continues, and we hope that in particular with today's event, we will really see Australia among the members and participants of the enlarged partial agreement. And I'm really also very pleased and happy to be present today on this event with our good friend and colleague, Professor Kerry McDougall, who really from the very beginning, starting from the February-March 2022, dedicated a lot of her efforts, time, and her thinking and ideas to the concept of the Special Tribunal and for making it happen. So our deep gratitude to Kerry from Kiev. I hope that she is happy to see where we are now. So in relation to the very question, in trying to answer the very question, I think that it is important that the Special Tribunal was born out of the legal discussion of experts supported by professional associations such as International Bar Association with Dr. Mark Ellis and fellow colleagues, supported by the national parliaments and international parliamentary organizations such as Parliamentary Assembly of the Council of Europe and the European Parliament. And then the key stakeholder in the Special Tribunal process was the core group, which included 40 states, 40 governments, plus several international organizations, on the level of legal advisors, so directors for international law. And we gathered for 14 times every 2 months, practically, in different cities around Europe to try to find the solution for the Special Tribunal. And it was a bit more than 2 years than the work on the model and concept of the Special Tribunal was finalized back then in March 2025. And I think that it is really very important to underline that each and every nation state who participated in the core group made its important input to the very outcome. So we had great cooperation with everybody there in the core group, including those states who are no longer present in this endeavor, but we are ready and happy to see their coming back soon. We are sure that it will happen. So the core group, really, these discussions, including with very important input from the Council of Europe, from the European Union institutions and services, really made it possible that we are now on the front line of the launching and operationalization of the Special Tribunal. Special Tribunal, which will be a separate subject of international law, which will have its own international legal personality, which will not be linked to Ukraine's legal and judicial system, which will use international law as a primary source, and which will use the internationally renowned and recognized definition of the crime of aggression, and this is really very important for Ukraine to see justice, which will be able to work in absentia, but with a full account of all the relevant international human rights law standards and rules. So I think that in the very end, the model and the features and the characteristics of the Special Tribunal, which we see now in the Special Tribunal statute, is really something what we could not even imagine that we would be there when we started this journey in February, March 2022. And I think that Special Tribunal perfectly fits in the system of international criminal justice as a complementary mechanism to the ICC, understanding the primacy of the ICC over other situations, over other categories of grave international crimes, in particular committed in the territory of Ukraine, but with the understanding that the only viable mechanism and instrument which is able to tackle and to ensure accountability for the crime of aggression against Ukraine is the Special Tribunal. So I think that this commitment and this dedication was shown for all these years by our fellow colleagues from the governments, by professional associations, by academic experts, by civil society. And I think that this is why we are there where we are. As Dr. Mudra mentioned, we hope that this week in Chisinau on Friday, we will have the adoption of the enlarged partial agreement on the management committee, which is the final element of the legal architecture of the Special Tribunal. Then, of course, the states will need to either ratify this enlarged partial agreement or make it legally binding for themselves through government procedures, like adoption of the relevant resolutions. But we hope that this will not take too much time, and we hope that the management committee, as an assembly of states parties of the Special Tribunal, will start its operations soon, and it will enable us to launch phase 1, which we call the Skeleton Tribunal. The Skeleton Tribunal, which will already be working as a separate international institution, which will be able to have its premises, to start its operations, to sign agreements with states and international organizations, and also to sign contracts on delivery of services, but still will not be able to exercise subject matter jurisdiction. Subject matter jurisdiction will be something for the phase 2 fully fledged tribunal. The tribunal, which will already have the roster of judges, appointed prosecutor, appointed president, and relevant agreements on cooperation with states, which we hope will enable the tribunal to be effective mechanism and tool. So, of course, Chisinau this week is not the end of the journey, but it is for sure an important momentum. which we need to gain together, and which we hope that will keep the ball rolling as efficiently as it is possible. We are now working hard. We have still some time, 5 days, to get several more notifications of states of their intent to join the enlarged partial agreement. Hopefully, there will be some more notifications this week, including from international organizations. And of course, as Dr. Mudra and Ambassador Miroshnichenko mentioned, it will be our privilege and honor to see Australia among the members of the enlarged partial agreement. We already have one state not from the European region, Costa Rica, which was already with us in this endeavor. We hope and we talk with our several other colleagues from other states, from North American region and Asian Pacific region, which we hope will join the endeavor. And of course, it is very important for us to see Australia in the list. And of course, it's no reason to say that the ability to join the process does not end up this week. After Chisinau, after the adoption of the EPA this week on Friday, our partner states will have the ability to join the process and to join the enlarged partial agreement anytime. So this is the open process. So we really hope that with such events, with support of expert community, of leading Australia's academics, experts, and with support of professional associations, we will make it happen, and we will have our Australian colleagues and friends on board. To finish up, once again, we are deeply grateful for all the assistance and support which we already got from Australia. This is very much appreciated on all the levels. And we hope that we will see our friends on the list. I thank you.
Thank you very much, Ambassador. Carrie, the ambassador spoke about the tribunal adopting the international law definition of aggression. So can you explain to us the crime of aggression, what it is in historical context, the significance of the tribunal in terms of the crime of aggression?
Yeah, sure. Thank you, Catherine. Thank you for having me here this evening to the Law Council of Australia. I guess it is kind of important to put the Special Tribunal in its historic context, because I think if you're not so familiar with the crime of aggression, it might be easy to assume that securing agreement on the establishment of the Special Tribunal was a relatively straightforward task. After all, we know that the General Assembly has been nearly unanimous in condemning Russia's act of aggression against Ukraine. We've heard Dr. Mudra outline the very compelling argument for why those responsible for that act of aggression must be held to account. But the reality is this is, a task of enormous significance. Colleagues on the panel tonight from Ukraine are incredibly modest, but I think it's very important for the audience to understand that what has been achieved is really something quite extraordinary. And this relates to the sensitivities that have historically been associated with the crime of aggression. And in some ways, the reasons why are self-evident. Unlike the other core international crimes, aggression makes individuals criminally responsible for certain violations of the jus ad bellum, the law on the use of force by states. And we know that the contours of the prohibition and its exception are unsettled, and they're hotly contested by states because it goes to the heart of national security considerations. If you add to that the fact that the Nuremberg-Tokyo definition of the crime, known as crimes against peace, became immediately outdated because with the adoption of the UN Charter, we adopted a whole new lexicon to describe unlawful interstate uses of armed force. And our understanding of the prohibition was premised on a functioning collective security system, which never worked as intended. You can sort of understand why this has been such a complex area of international negotiation. You add to that the fact that by definition, only the leaders of states can be prosecuted for this crime. You might start to understand why since 1945, the crime of aggression has been a really complex subject internationally. And it is, in fact, a disagreement over the definition of the crime of aggression that delayed the establishment of a permanent international criminal court for decades. In Rome in 1998, a majority of states were insistent that the crime of aggression be included in the ICC statute, but states couldn't reach an agreement on definition or conditions over which the ICC would exercise jurisdiction over the crime. So we ended up with a placeholder. The aggression amendments were finally adopted by consensus in 2010, but we paid a pretty high price for the aggression amendments. So crimes of aggression involving the territory or nationals of non-states parties to the ICC statute are completely excluded from the ICC's jurisdiction, and states parties are given an easy way to opt out of the jurisdiction of the court. That's not the end of the story. 7 years later, we had to activate the ICC's jurisdiction over aggression. And even then, what should have been a simple turning on of the light switch, as we used to say in New York, was again a really difficult diplomatic battle. We secured agreement to activate the court's jurisdiction over the crime, but it came at the price of inserting language in the activation resolution that purports to narrow the ICC's jurisdiction again. So I guess the picture I'm trying to paint is really that since its inception, the crime of aggression has been highly controversial, highly politicized, and the negotiations over the Special Tribunal need to be seen in that context. So the fact that Ukraine, with the assistance of its partners, have established agreement on a special tribunal is really something quite remarkable. The fact that they were able to do it with quite a small team of international lawyers and diplomats, all of whom were juggling other national key priorities, working in a very complex geopolitical environment. It's not a situation where you have incentives or threats that you can rely on to secure agreement. So it really is a testament both to the skilled diplomacy of the Ukrainian colleagues, including those ones joining us online tonight, but also the very compelling nature of the argument that Dr. Mudra and Dr. Koronevich have outlined, that it is really essential that we do everything we can to reinforce the prohibition of the use of force by making sure that those responsible for the most egregious violations are held to account.
Thank you very much, Carrie. And we might turn to Dr. Ellis to discuss some of the actual legal issues that will confront the tribunal as it goes about its business. And one of the key ones, I imagine, given the context of ongoing conflict, would be trials in absentia.
That's listening to what just Carrie had said and Anton had said, this kind of not an easy process here, and political considerations, compromises, and certainly during the process, as Anton said, these kind of 14 meetings in trying to get headway into creating this the statute. And so kind of from the civil society perspective, the trials in absentia was actually a really interesting issue, and one that remains somewhat controversial, although from my perspective, I'm quite comfortable with what the statute and what the tribunal will be doing. But, trials in absentia is really a balance. So it's a balance between trying to continue to demand for justice, in particularly when we're talking about kind of the heinous acts that have been committed against Ukraine. And of course, there's always the need to protect the rights of the accused. And international law generally leans towards the latter. And we saw that both in international tribunals that have emerged, with probably the exception of Nuremberg, that clearly stated that trials in absentia were authorized, and we know that that's what occurred in a number of those trials. But when we started moving towards creating international tribunals, ad hoc tribunals for the former Yugoslavia, Rwanda, there was a much more cautious approach to trials in absentia. And although both tribunals kind of expanded a bit the scope of trials in absentia, it kind of stayed pretty firm that we were not going to abide by that, not going to accept that. The ICC then generally came in, forbids the trial of a defendant if they're absent. So even in the statute, it says you have to have presence. And so the reason this is important is because for the tribunals, the modern tribunals, it was kind of leaning towards this idea that trials in absentia were something that was really not going to be accepted. There were some exceptions, but generally they accepted that. And then, of course, you have the domestic systems, common law systems, including Australia and where I live in the UK, generally prohibits trials in absentia. But civil law systems, including Ukraine, allow them. But international law generally says you have to have safeguards. And the safeguards are generally, do you have effective notification? Have you notified the accused? Have you attempted to notify the accused about the charges and the trial dates? The second safeguard is really legal representation. So even though the individual, the accused, is not present in the trial, you still have to have quality and a qualified defense counsel to represent him or her. And third, you have to have the right of retrial. So if the accused is apprehended later, this right comes into play. So for me, as in the International Bar Association, we said, well, let's look at this with the statute, with the statute for the Special Tribunal for the Crime of Aggression. And obviously, you have to start with this issue of wanting to have justice, and given the likelihood that these senior officials who are most responsible for the crime of aggression will clearly not voluntarily submit to the jurisdiction. And I think we have to say, at least in the short term, apprehending them will be somewhat of a challenge. So the statute, though, does permit trials in absentia where the interest of justice requires their presence, and if in fact the individual has waived participation, or the individual has been duly notified, or there's been an attempt to notify the individual. And so if there's an interest of justice to proceed with these trials in absentia, the statute allows the court to do that, the tribunal to do that. But most importantly to me, the statute is very clear that the whole framework parallels with the stringent conditions of international law. So the idea of notification, the idea of legal representation, and the right for retrial. And so when you look at that, my assessment from the start and my response to civil society was, I think the drafters of the tribunal, the drafters of the statute got it right. And I think we can now be very comfortable within the statute that in regards to trials in absentia, they meet the standards of international law and international procedure. And I think that gives me a great comfort, and it should give everyone comfort that the statute is adhering to those principles.
Thank you, Mark. And I think the other issue that's been raised is head of state immunity. And perhaps for some of the students who I know are listening, you could explain what that is and how it's relevant to the functioning and effectiveness and legitimacy of the Special Tribunal.
Yeah, Catherine, I think that's exactly right, because if trials in absentia was considered to be somewhat controversial, although as I've just described it, I think everyone should be quite comfortable with it, then the idea of head of state immunity, the idea that whether or not the trials in absentia could in fact be directed at what we refer to in international law as the troika, which is kind of the head of state, head of government, the Minister of Foreign Affairs. And generally, these individuals are protected under international law. So you wouldn't be able to pursue those individuals if, in fact, they're still in office. And so this is where the statute and the framers had to really focus on this, because, as I said, under international law, these individuals are protected. You cannot bring these individuals to account either for civil or criminal procedures in kind of a foreign national court. So, but you can, the exception was you can do it in international criminal tribunals. So head of state immunity, those protections that I've just mentioned that are embedded in international law, customary international law, they really don't exist for international tribunals, and particularly those that were created by the UN Security Council, supported by the UN General Assembly, or in multilateral treaties like the Rome Statute of the ICC. So when you look back, when historians look back to this tribunal, they'll see that there was a debate going on. Does the Special Tribunal for the Crime of Aggression, does it meet this threshold of an international tribunal? Because if it does, you don't have to recognize head of state immunity. You can pursue trials, arrest warrants against the even sitting heads of states. But this is where compromise takes place. And although there were a number of states who felt that the tribunal was international enough, a core group of states, and particularly the G7, they were just not ready to accept a situation to set a precedent to where head of state immunity would not be recognized. So that was the compromise. There was a compromise on this. And when you read the statute, it's really interesting because de jure, the statute says the official status of an individual will not protect those individuals from the court's jurisdiction. So in some ways, what the statute is saying is that we're not going to recognize head of state immunity in the same way that international tribunals do. But this is where the compromise came in. And when you look at kind of the de facto provision of the statute, and I think it's Article 25, the prosecutor will be able to investigate, will be able to prepare indictments against Vladimir Putin and others that are at the top level of this troika. But the pretrial judge will be required, once that's presented, will be required to suspend the proceedings until the individual leaves office. So you can't confirm that indictment. So this is a compromise. Some are not happy with it, but I tend to feel very strongly that without that compromise, we simply would not have been able to create this very, this key tribunal, and very unprecedented in many ways. So we're simply going to have to be patient. I always say international criminal law plays the long game. And even though you might think that Vladimir Putin and others will never be apprehended or brought to justice, history simply doesn't show that. History shows the opposite. And so this is the compromise we have to make, but we can still put together investigations. We can still put together indictments. And by the way, other than the Troika, there are a number of other political and military leaders, certainly inside Russia, that are not protected by this head of state immunity issue, personal immunity issue, and they can be pursued, including trials in absentia.
Thanks very much, Mark. So one more question for the panel before we turn to our audience for some questions. So I'd encourage the audience to use the Q&A function to type your questions for the panel. But while we wait for the audience, Mykola, can I ask you, a question. At the very beginning of the webinar this evening, Ambassador Moroshenko referred to other accountability frameworks that were currently on foot, a register of damage and a claims commission. Can you explain what they are and how the proposal for a special tribunal might relate to those other frameworks?
Absolutely. Thank you very much, Professor Renshaw, and good evening to our esteemed audience and dear colleagues. If I may just briefly follow up on what Mark has just said with respect to immunity, just a very brief comment on that. We were very strongly insistent on the exclusion of anything that would resemble immunity for the head of state. What was followed and what was the result of the compromise that Mark has mentioned is a practical arrangement that would suspend the criminal trial of the head of states, government, and foreign ministries, but it is not in any way and should not be construed as immunity. Because let's look at the definitions. If we take the Black's Law Dictionary, immunity means the exemption of liability. The current construction of the special tribunal does not exempt anyone from liability for the crime of aggression. Yes, it does suspend it, which was the necessary and forced on our side compromise, but it does not exempt Troika from any liability. So that is an extremely important notion because, of course, there are some critics. There are those academicians who call it an expensive moot court and other derogatory terms to downplay the significance of this common achievement. But in fact, this is the first major step since the adoption of the Kampala agreements to actually criminalize and enforce criminal responsibility for the crime of aggression. And I will now lead this to the other question that you have asked me. Indeed, the special tribunal, although it bears this central role in the comprehensive web of accountability that Ukraine, together with our partners, were building, it is not the only one. So if you've had the chance, our dear audience, to review the statute of the Special Tribunal, it has some of the explicit mentions about the link that this Special Tribunal has with the other elements. And the other, of course, very important element that Ambassador Miroshnichenko and Dr. Mudra have already mentioned is the international compensation mechanism, because the Special Tribunal will only review the individual criminal responsibility of those who bear the greatest responsibility for the crime of aggression against Ukraine. It will not assess the damages caused by the crime of aggression. It will not address the full representation of victims. We do have a provision for tailored victim representation. It is out there in this special tribunal statute, but having tens of millions of people, countless legal entities, and the state of Ukraine as the victim of aggression, or as some have said in the core group, the whole international community of states as the victim of this aggression, it is not really feasible to make sure that they're all represented through this mechanism. So in order to address the damages, loss, and injury caused by the special tribunal, my apologies, by the crime of aggression, we have already begun constructing what's called the international compensation mechanism. It kicked off with a historic resolution of the United Nations General Assembly in 2022, was called Furtherance of Remedy, in which 94 states have recognized that the Russian Federation must bear all consequences, all legal consequences for its aggression, including compensation for damage that has been caused. That very same resolution has recommended the creation of the Register of Damage, which we then swiftly launched within the framework of the Council of Europe, but open to all states. And we are absolutely overjoyed to welcome Australia in the Register of Damage. In last August, we had a by now it's the last member to join, but not the last in overall, and that's where we really hope to see your kind support with the outreach to the Pacific. As Dr. Mudra said, that has been one of the primary purposes of our visit to Canberra, Sydney, Auckland, and Wellington just 2 months ago, where we engaged with the Pacific Islands diplomats and legal societies. We're really, really hoping on your support in making sure that we make these instruments as global as possible. The Register of Damage, launched 2 years ago, has its first 150,000 claims. It accepts claims for damage, loss, or injury on 43 different categories, not limited to Ukrainian nationals. Actually, anyone who has suffered damage, loss, or injury, including Australian nationals, including companies, or those service people who have fought in the war for Ukraine against Russian aggression. And if they have suffered injuries, they're eligible for compensation. If unfortunately they have fallen in battle, their families are eligible to compensation. And we do know that there are quite a lot of soldiers from, if I may call, Anzac, fighting on our side. So it is a great honor for you to have you with us, not just in legal battles, but on the battlefield as well. And that's very important that this mechanism covers these damages as well. So the next element of it, so the register only accepts claims. It does not do any review outside of the basic eligibility assessment. The next element is the Claims Commission, where we are following the precedents of the United Nations Claims Commission, Compensation Commission, established after the Iraqi invasion of Kuwait. We also draw experience from the Eritrea, Ethiopia Claims Commission, and in the Iran-US Claims Tribunal, where the damage caused by international wrongful acts have been reviewed. And so the construction of it is now enshrined in the Convention establishing an International Claims Commission for Ukraine, which has been signed in December in The Hague, last December, and it's now open to not only signatures, which have been 36 we had, but also ratifications. And the first ratifications start kicking in. We need 25 for it to enter into force. And then it will be created, and we'll start reviewing the claims and assessing the damage caused by the aggression. Now, where is that link? I know I've had a very lengthy introduction. The very direct link is in Article 37 of the Special Tribunal statute. The Special Tribunal shall order funds collected through fines or confiscation measures to be transferred to an international mechanism, giving priority to a compensation mechanism established in accordance with UNGA resolution of 14th November 2022. So that is the direct link. The tribunal, which has the possibility, that's the Article 36, that in addition to imprisonment, the trial chamber may order a fine or the confiscation of instrumentalities, proceeds, property, and assets derived directly or indirectly from the crime of aggression without prejudice to the rights of bona fide of third parties. So that is one of the ways that the compensation mechanism can be filled.
Thank you so much, Mikola. You mentioned the Kampala amendments, which brings us to the International Criminal Court. So what is the relationship going to be between the Special Tribunal and the ICC?
Absolutely. And this is one of the very important questions that we've heard a lot since, again, not absolutely everyone in the world is on the same page with us with respect to the Special Tribunal. And we're really doing a lot of work to try to explain that when the concept of the tribunal was crafted in the first place, exceptional importance, exceptional attention was paid to the correlation between the Special Tribunal and the International Criminal Court. And we have engaged with the administration of the International Criminal Court, with the judges, with the registrar, to make sure that these two mechanisms do not in any way encroach on each other, and on the contrary, complement each other. And that is achieved practically through a very concrete provision in the statute of the Special Tribunal, which provides that in case that a person is apprehended, which is wanted by the Special Tribunal, the preference shall be given to the International Criminal Court. So in our current situation, as as I'm sure the audience knows, the Kampala amendments preclude the Russian Federation's leadership from being tried by the ICC, because we are highly likely to have a referral by the United Nations Security Council, nor obviously Russian Federation is not a party to the Rome Statute or the Kampala amendments. And in any case, they wouldn't address the start of aggression in 2014. That is a very, very important point, and one we're still fighting for in the international compensation mechanism, by the way. It is limited by 2022, but the war began in 2014. So one of the important hopes we have for the tribunal, that it will be able to establish that the war began in 2014, the war of aggression. And in that way, there is no competition with the International Criminal Court whatsoever. I will even argue that the Special Tribunal reinforces the International Criminal Court and gives more momentum to the prohibition of the crime of aggression, which would only reinforce the relevance of the International Criminal Court, because we don't want a new Special Tribunal created every single time. This is one of a kind, an ad hoc solution to an existing glaring gap in the accountability system that we have right now. But if we are able to successfully launch it, then it will become an important precedent for further harmonization of the ICC's jurisdictional regimes.
Thank you so much, Mykola. We have some.
Catherine, could I respond or add one thing, because Mykola's point reminded me of something that I think is really critical here, because he's reiterating so rightly that the statute simply does not recognize head of state immunity. So that's that. And we've talked about kind of the compromise that there will be a temporary hold if there's an attempt to pursue an arrest warrant against the Troika. And we've said there are lots of others, a number of other leadership individuals in leadership, political and military, that are not protected at all. But the other thing this statute does, it does not recognize functional immunity. And that's really important. So functional immunity generally would have allowed Vladimir Putin or others to argue that, well, you cannot pursue actions against me because I was simply doing my official duties. That's what functional immunity is, and that's embedded in international law. This statute says we simply do not recognize that. That is absolutely an advancement of international law, particularly in relation to what the International Law Commission has argued, and the issue of the crime of aggression is not, the acts towards a crime of aggression is not going to be seen in any way as part of an individual's official duties. The statute doesn't recognize it, and that to me is critical, because once Putin leaves the office, he's not protected by functional immunity.
Thank you so much, Mark. That was an incredibly important clarification there. We do have some questions from our online audience, which is terrific. Please keep them coming. The first one is from Vishal, who thanks you for the insightful session and asks how the Special Tribunal for Ukraine is different from contemporary special tribunals, particularly in addressing several drawbacks noted by academics and scholars in other special tribunals. So, Carrie, I wonder if that's a question that you might be prepared to take a first pass at from an objective academic point of view, the comparative issue.
Sure, I can certainly offer some initial comments and we'll welcome other panelists' responses as well. But I mean, the main difference is, of course, this is the very first ad hoc tribunal in the Charter era that has jurisdiction over the crime of aggression. So in many ways, the tribunal will be breaking new ground in offering an interpretation, in particular of the definition of the crime and its very complex mix of state act elements and individual conduct elements. The other, I guess, if we think beyond the subject matter jurisdiction of the tribunal, the other thing I would highlight, I think points that have already been made by Dr. Mudra and Ambassador Koronevich, but the way this tribunal has been designed really does reflect a lot of the lessons learnt from the earlier ad hoc criminal courts and tribunals. So in terms of how the judges and prosecutors are going to be appointed with I think a huge effort has gone into making sure that it is a robust, merit-based process. That the footprint of the tribunal is going to be small, commensurate with the fact that we only need to investigate, one particular crime, the crime of aggression, with a defined number of individuals who could potentially meet the definition of a perpetrator. And Dr. Mudra and Ambassador Koronevich have sort of talked about the phased nature of the establishment of the tribunal, which has really been designed to ensure that the costs of the tribunal are kept realistic in the contemporary era. So, I mean, I think the design of the tribunal absolutely takes into account lessons learnt from the experience of other ad hocs.
Thanks so much, Carrie. Would other members of the panel like to comment on this question as well?
If I may, I just want to recall Madam Mudra's words from the opening remarks about this tribunal built in the ongoing war. And what we see here is like when we have analyzed all the previous tribunals, and I remember I had the discussion with one of the delegates of the core group members, like, okay, but you can't create a perfect tribunal. And I've said, of course, we cannot. None of them have been perfect. All the previous tribunals, while serving an important part to advance justice, they had significant drawbacks. And for Nuremberg and Tokyo, we've read and extensive criticisms about them being the victor's justice, where the defendants were basically a defeated country, which and the justice was forced on them. And I think that this special nature of this tribunal lies specifically in that it is not linked to that geopolitical reality where the defendants come from the defeated state. And that gives so much more credibility and so much more integrity to the proceedings that we're about to start, that it truly marks it as one of the most outstanding special tribunals that could have been.
Thank you, Mikola. Now, you mentioned, Carrie, the process for appointing judges, and we have a question from Dominic Harvey Taylor about what that process is going to be, and a very specific question about where the tribunal will be established. So, Dr. Mudra, do you have details about the process for appointing judges, or is someone else better equipped to discuss that?
Well, of course I do have, but it's better that the experts who were drafting the charter, the statute, and discussed on daily basis with the legal advisors from our partner states, allies, they would be more precise in answering this question. So I invite Anton to give the precise answer. Thank you.
Anton.
Thank you so much, Professor. Thank you, Dr. Mudra. Well, yes, of course, this is all part of the statute of the Special Tribunal, which is an inalienable part of the agreement between Ukraine and the Council of Europe on the establishment of the Special Tribunal. So the statute is published in English, I believe, on the website of the Council of Europe. It's published in Ukrainian on the website of the Ukraine's parliament. So I think that if the questions emerge, it will be really useful to read the text itself to analyze it. But yes, the provisions are quite simple. So the management committee votes for the appointment of the judges and of the prosecutor, because management committee is something like Assembly of States Parties, and each state which is a member of the enlarged partial agreement on the management committee then participates, is presented in the management committee and has one vote. So any person can be judge in the special tribunal. So a state can nominate a person, and a state can nominate a person notwithstanding the nationality of this person. So it can be national of any state of the world, including from potential aggressor states always. So there is such a possibility. And then there is this voting, and then the judges are appointed to the roster. So it is very important, I think, to mention that we understand, and we understood from the very beginning, that the matter of costs, of price of all this endeavor, of all this enterprise, should not be a burden and should not be something which impedes, which hampers us from moving forward. So in places where we could have some, cost efficiency mechanisms applied, we try to do this. And that's why the judges are appointed on the roster, and then they are called onto the office to do their job only when there is a necessity. And they are paid for only when they do the job where there is a necessity. Only a president work permanently if we talk about the judges of the tribunal. So in such a case, and of course, all the rules which are applicable for the candidacies for the role of the judges are the same as it is in the Rome Statute of the ICC. In relation to the place, of course, we hope that this will be The Hague. And of course, we hope that this will be The Hague. There is no better place, the city of justice and peace, the city which hosted pretty much all the key international judicial bodies which acted these decades. And it's important that the Netherlands have already made a political decision to host phase 1 skeleton tribunal. So it's already decided that it will be in The Hague. Now the only question is to find the appropriate premises. And now we work together with our Dutch partners for them to have a decision on hosting also the phase 2 fully fledged tribunal. I thank you.
Thank you, Anton.
But actually, what Anton said is so clear, and one of the other elements of this that I think from civil society we really like is that there's with the statute an independent advisory panel that has been created, and that independent advisory panel will also look at, as Anton had said, the recommendations for judges from the management committee, and they will objectively look at those recommendations and then return back to the management committee their own recommendations, having objectively look at that. I think that is such a significant add-on to this tribunal that it once again shows that we're going to be transparent, that we're putting in independent voices, and it's another, I think, real achievement for what Ukraine has created with the Council of Europe on this. Really, really significant.
Thanks, Mark. There's a question from the audience about Crimea, and I think it's a political question about the compromise that's having to take place with pressure from nations pursuing peace over justice, etc. How do we make sure that the conversation remains on Crimea and justice for Crimea as well?
Actually, indeed, this is the political issue. Well, Unfortunately, the register of damage, its statute says has three criteria which should be followed when the applicator sends the application to the register. And one of the criteria is that the damage is caused on the territory of Ukraine on or after 24th of February 2022, and it limits the assessment of the damages to the period after 2022. But as we all, and this is because in the resolution of United Nations, it was stated that the Russian there was that definition of the act of aggression committed by Russian Federation after 24th of February 2022, and this is the direct link to this resolution in the Federance and Remedy Resolution of United Nations. But we at the Assembly of Participants of the Register of Damage, as well as of the Claims Commission, we always say that the war of aggression was launched by Russian Federation not on the 24th of February 2022, but on the 20th of February of 2014. So we continue to insist on expanding the time limitations for the registers of damage, as well of the for the Claims Commission, as well as for the tribunal. And tribunal does not specifically mention any date or any events which could be linked to the period starting from the 2022. So we do believe that Ukraine will be heard, and the participants, the parties to the convention and parties to the this enlarged partial agreement in future will be able to expand this period for 2020 to 2014, so that to encompass the events which had place in Crimea. But for Crimea, if we speak about damages, we have already existing tools, legal tools, to compensate these damages. These are investment arbitrations, investment tribunals, and we have a lot of awards of investment tribunals awarding the compensation for the lost assets in the Crimea. But if we speak about the act of aggression, about the war of aggression, of course, it should be the Special Tribunal on the crime of aggression who should also consider the events which have been held back to 2014.
Thank you very much, Dr. Mudra. I think we have just another couple of questions, but one of them is from Judge Natalia Iakusha, a Ukrainian judge at the Kyiv District Court of Kharkiv. And Judge Iakusha says that Dr. Kornievich mentioned that the tribunal will conduct proceedings in absentia while fully respecting international human rights standards. From a practitioner's perspective, this is one of the most technically demanding commitments to honor in practice. Ukrainian courts have been navigating fair trial standards under conflict conditions since 2014, including cases where defendants were unreachable or in occupied territories. Has the tribunal's drafting process drawn on this body of national judicial practice? And if so, how has it informed the procedural safeguards built into the statute? Anton, I think that one is for you.
Thank you, Professor Renshaw. Yeah, I can start, but of course, if the colleagues would like to add something, this will be amazing. So yeah, thank you for this question from Madame Yakusha. It's really important to have Ukrainian judges here with us. Many thanks for that. Well, when we drafted the statute of the Special Tribunal, I may not say that we highly relied on national practice of Ukraine or any other state. But what we did, I believe, is more important. We relied on best international standards and practices, and mainly on European Convention on Human Rights and European Court of Human Rights. So this is a key thing, because what is the body of law which is normally considered when we talk about abuses during proceedings in absentia? European Convention. And what is the forum who actually does this job and says whether the national courts did right or wrong when doing proceedings in absentia? For our European region, this is surely European Court of Human Rights. So I want to assure Madam Judge and everybody present here that while we were drafting the statute, we drafted it in strong conformity with provisions of the European Convention and case law and practice of the European Court. We had colleagues from the Secretariat of the Council of Europe drafting these provisions, and we had jurisconsults, lawyers of the European Court of Human Rights, then analyzing the provision and advising on them. So I am pretty sure that how the section on trials in absentia is drafted now in the statute is pretty much the best available international standards which are currently available. And just to maybe finalize the answer to this question, I think that those present on this webinar understand this, but still it's very important to mention. Proceedings in absentia, I believe Mark spoke about that already, but still, proceedings in absentia will be one of the most important features of this tribunal, because it will be able to go deeper and more broader than any other tribunal in the world, with not only being able to issue arrest warrant while the accused is not there physically, but making a verdict. And for us, for Ukrainians, here in Kyiv, Kharkiv, Lviv, Odessa, any other place, it's important that they are not only alleged criminals, but they are criminals with verdicts. It's important for truth, it's important for history, it's important for justice. So I'm really sure that together with our colleagues from the Council of Europe, we made everything possible so that the in absentia provisions are strictly in conformity with the best international standards. Thank you.
Thank you, Anton.
Yeah, I want to reiterate that. I think Anton is talking about this kind of demand for justice, and Ukrainians want it, the international community wants it. But when you look at the statute in regards to trials in absentia, and the question is, for me, does the statute set out the protections, the requirements under international law for impartiality, fairness, absolutely the protection of the accused? For me, the answer is yes. It checks those boxes, and in every question that I made or others made as to whether or not the tribunal statute meets these standards, my view is they absolutely meet the standards. Implementing those will always be a challenge as you get into the case process. But I don't think anyone should be concerned about the legal basis that the statute sets out for trials in absentia. They do meet international standards. I'm certain of that.
Thank you very much, Mark. There are another couple of excellent questions from the audience, but we really need to turn now to final statements or observations from the panelists to conclude this webinar. So if I could just ask each of the panelists to provide some final reflections, both on the significance of the Special Tribunal, what it could augur for the future of Ukraine or for international law, please. I might begin with you, Mykola.
Professor Renshaw, may I start because I need to run. I want really to thank you very much and thank the audience and thank what you are doing to support this tribunal. The Special Tribunal is no longer a proposal. It's becoming an institution. What remains now is ensuring that it becomes truly global, and this is where the Australian legal community can make your historical contribution, like as lawyers, as scholars, as advocates, as advisors to government, as defenders of international law. Your voice matters, because this, in moments like this, silence also also a choice. And later on, history always remembers which side serious legal communities choose when the international order was under pressure and threat. So our message is simple: join the tribunal, defend the prohibition on aggression, help ensure the law remains stronger than force. Ukraine, as I said, will never compromise on justice, and we do ask the legal community of Australia to stand with us, to contribute into this and to support this. Thank you.
Thank you very much, Dr. Mudra. We will let you go to your meetings.
Thank you. Thank you.
Mikola.
Yep. Well, it's hard to say something after Madam Mudra, but I will take this opportunity to also briefly address two of the questions, because I think they tie up to the overall questions that we hear a lot. What if Putin stays in office until he dies? Then he's not held accountable. He will be. The indictment, and this is the answer to Reggie Burton's question as well, is that we can charge Putin, and we will charge, and we will indict him. The process will stop, right, for the procedural limitation, as he is the head of state, but he will get his indictment in the crime of aggression, and that is extremely important. And if we look at this from the game theory perspective, the impact that will this tribunal and the indictment on the head of state, which started the crime of aggression, will have on the foreign policy calculus of all Putin wannabes who are considering starting wars of aggressions of their own, cannot be underestimated. And this is why we're traveling around the world. We've been in Latin America last year. We've been in Australia and New Zealand this year, in certain African states. And we're trying to unite the world and explain that this is not only about justice, this is about global security. In a time when world leaders are questioning the very existence of the rules-based order, yes, this is a very practical and pragmatic tool to actually try to bring it back alive. Yes, it's a long way to the top if you want to rock and roll, but we have now all the elements for it. So for those about to rock, we salute you.
Thank you very much, Mikola. I appreciate that gesture of humor there in such serious circumstances. Anton.
Thank you, Professor. Well, very briefly, I think it's obvious that the Special Tribunal is of key importance for Ukraine. I think it is obvious that we will not compromise on it. So all the things which we can do together in order for as many states to join the effort as possible, this is of critical importance. And of course, we will be happy to see Australia in the club. Now it really looks like the legal job is done. The drafts are there. The legal job was done in a nice manner. There is nothing ideal in the world, but this tribunal is very good enough to be efficient and to be successful. So while the legal job is done, I'm sure that there will not be a lack of political will to make this a real life story. Thank you.
Thank you, Anton. Carrie.
Thanks, Catherine. I sort of, even though it's repeating the message, I think, as the Australian panelist, as a former government lawyer for DFAT, as someone who's been working on the crime of aggression for more than 2 decades, I actually think it's really important that you hear from me that I also think it's Absolutely critical that Australia join the enlarged partial agreement in order to demonstrate its support for the Special Tribunal. The Prime Minister, the Foreign Minister, the Defence Minister have all made it very clear in their public statements that, in their view, Ukraine has been the victim of an egregious act of aggression and that those responsible should be held to account. So, consistent with that position, Australia should back the Special Tribunal. And in my assessment, that support is critical for Australia's credibility in terms of our commitment to the rule of law and the prohibition on the use of force in particular. But as our colleagues have explained, it's also important for the credibility of the Special Tribunal. The support of a geographically diverse group of states will send the strongest possible message to perpetrators and would-be perpetrators of the crime of aggression, that you cannot commit an act of aggression against another state and get away with it.
Thanks so much, Carrie. Terrific. Mark, final
Yeah,
word.
just shortly, it's following up on what everyone has said, but I think it's really important to reiterate that, yes, this is an egregious crime against Ukraine and its people, and they deserve justice. But this affects and impacts the international community. 80 years ago, the UN Charter was created. Article 2, for me, is the most fundamental principle of the UN Charter. It says you cannot use the threat or use of force against the territorial integrity or political independence of another state. That is the crime of aggression. And what this special tribunal is doing, it is an arc of international justice. And so what has not been able to be completed up to this date can be completed with the Special Tribunal for the crime of aggression. It can be very firm in stating the international community will uphold the UN Charter's principles against the crime of aggression. This is why this tribunal needs to succeed, not just for Ukraine, but for the international community and for the legal order that emerged out of the Charter.
Thank you so much, Mark. And the final word for Ambassador Miroshchenko. In one of the comments from our audience, we've had the ambassador paid the ultimate Australian compliment by saying that we rate the ambassador and he really gets Australia. So that is as good as it gets from an Australian.
Thank you, Professor. It was a great pleasure to attend the webinar. I've learned a lot, and I look forward to working with Australian government in ensuring that they may have all the necessary information to make the right decision. And I've met your foreign minister many times, and I know how important it is for Minister Wong the issue of justice, and given what she's been doing all her life and the principles that are so dear to her. And I think the rule of law, the international rules-based system, is something that she seriously keeps extremely invaluable, and something that there could be no compromise on that. So I remain hopeful, and I stand ready to work with DFAT on these issues and serve as a bridge between Kyiv and Canberra. And of course, I look forward to engaging with the academic world. And of course, as I said, for me, I'm not an international lawyer, but certainly for any student of international relations, international law is so important. It's fundamental for the way governments and states engage with each other. So thank you very much again for hosting this webinar, and thank you to all the panelists and the great questions.
Thank you very much, Ambassador. So I would like to give a final thank you to the panelists. It was an extraordinary seminar. I'd like to thank the audience for showing their commitment to the rule of law and the pursuit of justice by participating in this webinar in the way that they did. And I wish you good evening or good morning, depending on where in the world you are, and thanking you again. Good night.
Good night.